Welcome again, everyone, to Koranteng Koranteng's second quarterly webinar on buying property in Ghana, the due diligence process. My name is Kensah Ashkar, and I'll be hosting today's webinar. K&K is a corporate and commercial law firm in Accra, made up of barristers, solicitors, and consultants, providing value-laden legal advice backed with a cumulative experience of over 30 years with expertise across diverse sectors. Our guest speaker webinar are Emmanuel Sackitey Mate-Kole. Timothy will give his presentation. I will do the same for the second and then the third. Following the presentations, there will be a question and answer session where presenters will answer questions left for them in the chat box for their attention throughout the presentation. So please feel free to leave any questions you have in the chat box, and we will attend to them when we are done with the presentation. After all the questions are answered, or if we are short of. The real estate market in Ghana has experienced a boom over the past few decades, and this boom has often been attributed to the growing middle class, Ghana's stable political climate, and people's increased understanding of investment, using properties as investments. Land is scarce, but society views land ownership as related to wealth, power, and authority. And so it's not unusual to see families torn apart, couples battling in court, and even countries in ruins over land disputes. Real estate dealings in Ghana have been plagued by fraudulent activity. It seems like everyone knows someone who has been affected by the land troubles we have in Ghana. Some of the risks we have associated with buying property in Ghana are land title disputes, and that's when different people lay claim to the same parcel of land, boundary disputes, and failure to consider environmental elements when purchasing land. There's a risk of losing one's investment or being embroiled in legal disputes over a number of years if you don't take care. This is why the common law maxim of caveat emptor exists. It is Latin for let the buyer beware. In fact, the whole phrase is let the buyer beware, for he ought not to be ignorant of the nature of the property which he is buying from another party. It is ultimately the buyer's responsibility to do due diligence, you see, not the seller's. So the buyer has to make sure that they do the work to find out if there's any defect with the land that they wish to purchase. They must conduct due diligence. And due diligence, according to the Cambridge Dictionary, is an action considered reasonable for people to take in order to keep themselves or others and their property safe. It's a comprehensive exercise, and it involves investigating, analyzing, and evaluating a transaction. Due diligence is required to verify information such as the authenticity of land, title, claims of ownership, and to ensure property is free from encumbrances or disputes. It helps to identify and assess potential risks and liabilities and ensures the transaction's legality and viability. So it allows the buyer to make informed decisions and mitigate any risks that he may encounter along the way. It covers various aspects: legal, finance, financial are some of the things that you can find in the due diligence process. But I will leave the details to our speakers to give us. Each speaker will cover a different aspect of the due diligence process. And by the end of this webinar, you should have a holistic view of what it means to conduct due diligence when buying property in Ghana. So I will introduce our first speaker, who is Mr. Emmanuel Sackitey Mate-Kole of M&O Law Consult. Hello, Emmanuel. He's an award-winning lawyer and the founder and managing partner of M&O Law Consult. His firm was awarded Real Estate Law Firm of the Year 2023. He has deep experience in real estate and infrastructure, and much of his recent transaction and advisory work focuses on due diligence, security-related issues on transactions, and corporate authorizations. And with his background and experience, he often speaks at industry conferences and publishes on diverse topics, including how to avoid tax liability arising from property sale, what you need to know about land ownership in Ghana, how to evict a tenant in 10 steps, how to avoid land litigation, and more. He's my senior, and I actually interned with him a number of years ago, I think about 10 years ago, when he was working elsewhere. Thank you, Manuel. Over to you.
Thank you very much, Kensah. All right, thank you. All right, so like my colleague rightly said, my name is Emmanuel Mate-Kole. I'm a real estate attorney and managing partner of M&O Law Consult. So today I'll attempt to take you through the land buying process in Ghana. It's some portions of it will be a bit technical, but I will do my best to break it down. Now, if you find anything difficult to understand, just note it in the comment section or send a question, and after the presentation, I'll do my best to address it. So I've assisted clients to secure their interest in land in Ghana by conducting due diligence, by assisting them to prepare the requisite documentation, and by registering. Now, the procedure, which is the procedure for the acquisition of the land and the registration of the title alone, is not enough. You also have to take steps to protect your interest in the land and to prevent others from taking away your land. So land ownership is something that you ought to be vigilant about. You cannot just, you cannot be indolent or take things for granted. You have to take positive steps to ensure that you keep what belongs to you. There are 3 stages of a land transaction. We have the pre-closing, closing, and post-closing stages of a transaction. I'll focus on the pre-closing and the closing stages. I believe one of the panelists will do the post-closing stage. Now, the pre-closing stage is mainly the due diligence stage. And I encourage everyone who wants to buy property in Ghana to engage the service of a lawyer. It is very important because there's no way you can do, you can get a valid grant. Let me put it that way. Let me just be blunt. There's no way you can do a good transaction or get a valid grant in law if you don't use a specialist. And after the presentation, you understand why I'm saying that. Now, the due diligence required, and this is not exhaustive, but this is what, for purposes of this presentation, this is what I've put together. So the due diligence required to acquire property first is a search at the Land Use and Spatial Planning Authority. This was called the Town and Country Planning Authority. And then subsequently, the name was changed to Land Use and Spatial Planning Authority, although the name Town and Country Planning Authority is used in some cases. The appropriate name is Land Use and Spatial Planning Authority. Now, they are responsible for developing planning schemes in various areas in Ghana. And the rule is that, according to the Local Governance Act, if you are given a grant of land and the grant states that the land should be used for commercial purposes, but the area has been zoned for residential, it means that that grant is void. It's just that simple. So assuming that there is an issue which comes up and I'm in court with another party, and I find out that the person has in their lease agreement a grant to use the land for commercial purposes, and I do a zoning search and I find out that the land has been zoned for residential purposes, even if the person has a land certificate, I can, on the basis of the zoning report, state that this transaction ought to be set aside, and it will be set aside. There's also the search at the Lands Commission to confirm if, first of all, there are 3 searches that you do at the Lands Commission. And recently, what they do is they give you a consolidated report. So there are 3 divisions of the Lands Commission. There's the Public Invested Lands Management Division, the Survey and Mapping Division, and the Land Registration Division. The Public Invested Lands Management Division used to be called the Deeds Registry. And then subsequently, it was renamed the Public Invested Lands Management Division. So although it says Public Invested Lands Management Division, it gives the impression that it has records on only public invested lands. It does have records on individual lands as well, and stool lands, etc., and family lands. So this division will give you a history of all the transactions on the land. So historically, whatever transaction has taken place on the land, PVLMD will give you that story. It's called PVLMD for short. Now, this is very important because when it comes to real estate transactions, you are looking at the historical transactions. To impeach a transaction, you have to go back to see whether the person's predecessors in title did the right thing. Because in law, you cannot put something on nothing. So if the predecessors in title did the wrong thing, it means that the legal nexus is broken. Whatever continued after that doesn't have a legal connection. It's a baby without a cord, an umbilical cord. So it's basically that transaction can be set aside simply because of the antecedent transactions. And in our country, we don't have insurance for defective title. In the US, they do. They have title insurance. In Ghana, we don't. So you ought to minimize your risk from the beginning before you enter the transaction. So looking into the past to correct the mistakes will enable you to give your client a good title in the present. Then there's the Survey and Mapping Division search, which will show you the people who have actually applied to get a land certificate. What has happened is that they apply and they are given a letter to prepare a cadastral plan. When the cadastral plan is prepared and handed over, then they will plot your name at Survey and Mapping Division. But Survey and Mapping Division does not show that you have title. It just shows that you are in the process of obtaining title. Now, at a point, the cadastral will be published. And before the publication is done, they will check to see whether the person who is giving you the grants has their name at the Public Invested Lands Management Division. If they do, the publication will be done. And if no objection is raised within 21 days, you'll be given a land certificate. But Survey and Mapping Division does not mean you have title. It is Land Registration Division, the final division, that gives you title. Now, once you have a title from Land Registration Division, it means that that title is indefeasible in the absence of fraud and some other vitiating factors. Then there's the new secretariat established by the Lands Commission, the Land Act, called the Customary Land Secretariat. They record customary transactions. So for instance, if you have a stool that owns land, they will first of all establish this Customary Land Secretariat with the help of the Lands Commission and the Office of the Administrator of Stool Lands. And then they will record their transaction that they are the allodial owners of the land. If they've registered it, they will record that they have registered it as a customary transaction. Then any subsequent transactions which are customary will be recorded. Then the litigation check, which is very important because in my experience, a lot of land or prospective purchasers enter into transactions without doing a litigation check, and the sellers will also not disclose that they are in court. So it's imperative that you do a litigation check to find out whether the property or subject matter that you are interested in is a subject of litigation or not. So this search is very important. Then you also request for title documents from the seller, because the rule is that, and everything I'm saying is by law. I mean, the law provides for it. I'm not creating anything. This is everything I'm saying is law. So the law provides that if you are going for title, or if you are going for land, and your tenure is going to be 3 years or more, you should call for all the documents, including the mother documents, which is called the head lease, and review it. It's very important that you do this, because then you'll be minimizing your risk, like I said. You review the head lease and ensure that all the covenants in the head lease are respected by you, both past and future, because there's an implied covenant in the law that if you are taking land from somebody, you are observing the past covenants and the future covenants. So it's imperative that these covenants are respected, because if you don't, it will amount to a breach of covenant, and the consequences are the head lessor can come for damages, they can re-enter the land, so many other things. All those things will be in the head lease. So you will see them once the documents are reviewed. Judgments are very important, and this is why. So under the Land Act, a judgment which has been registered must satisfy certain requirements. 1, the judgment must indicate the interest of the person who won the judgment, because there are different interests in land. We have allodial interest, we have usufructory interest, we have customary freehold, common law freehold, leasehold interest, customary tenancy. All these are interests in land, and the judgment must indicate the interest that the person has in the land. The judgment must have a judgment plan signed by the registrar of the court and the judge. Now, if you review a judgment which has been plotted at Lands Commission, which does not have these things, then that plotting has to be expunged. And you can go to court to have it expunged, because the rule says that no judgment ought to be registered if it does not comply with these requirements. Now, mind you, I have realized that a lot of people are reluctant to pursue their rights because they feel if you go to court, you will lose, or it takes too long to have a determination made in court. I am in the practice, so I know that sometimes things take a while. But let me tell you something. If a judge is supposed to apply the law and the judge does not apply the law, then the judge has applied another thing. It could be morality or something. But if that decision is put to strict proof, I mean, if that decision is tested, that decision will be set aside. And this is something that has been done several times. Once a judge makes a decision and assigns or ascribes a rationale which is not legal to it, that decision is what we call per incuriam. That decision cannot stand. So if you have a decision, if you have a matter in court and you lose at the High Court, it doesn't mean that if you go to the appeal court, you lose. And if you go to the appeal court too, it doesn't mean that if you go to the Supreme Court, you will lose that matter. Once the decision is per incuriam, you can have it challenged. So the judgments are also very important, because the law has to review the judgments to ensure that the judgment is in compliance with law before advising the client. Then obviously approve site plans. A site plan cannot be a subject of registration, or you cannot register a document which has a site plan that has not been approved by the Director of Survey registered. That is a subject of law. And also, I've noticed that a lot of people in transactions sign the back of the site plan, the grantor and the grantee, or the lessor and the lessee sign the back of the site plan. The law, there's no law which says that the back should be signed. The law is that the person who a conveyance, if it is not a conveyance, then it has to be, the back of the side plan has to be signed. So if it is a conveyance, that is from one person to another, you don't have to sign the back of the side plan. But if it is a statutory declaration where an allodial owner is registering his title, he ought to sign the back of the side plan because that is not a conveyance. So this is just for information. Then ground rent searches, property rates, and utility bills. You ought to check for all of these things to make sure that no liens are on the property. A lien is when somebody has a charge on a property simply because you owe them money. And what they can do is that they can enforce that by selling your property to recover their money. So ensure that ground rent searches, property rates, and utility bills are paid fully before the transfer is consummated. Then, in the case of stool lands, I recommend that a search is done at the National House of Chiefs, which is in Kumasi. This is because a chief cannot exercise his statutory duties if he is not gazetted and his name is not published in the chieftaincy bulletin. These are two requirements: gazette, or let's say registered. You should be registered at the National House of Chiefs, and your name ought to be published in the chieftaincy bulletin. If you don't have these two, I'm sorry, you cannot sign a document on behalf of a stool as a chief. You cannot enter into contracts on behalf of the stool as a chief. That transaction can be declared void. Traditional council searches. Traditional council is made up of the paramount chief and lesser chiefs. It's imperative that these searches are done also because sometimes there's a dispute between two chiefs on boundaries, and you will not know this until you've gone to a traditional council to inquire. Some of them, they resolve disputes at the traditional council. So it's imperative that this search is also done if the land is stool land. A search at the Forestry Commission. So under our law, there are certain interests that can be registered, and that is those interests are in respect of land. But our land does not include the land, the land that is registrable does not include the natural resources. So gold and other minerals are not governed by the Land Act. They fall under the Minerals and Mining Commission. Then timber rights do not fall under the Land Act. They fall under the Forestry Commission. So if you want timber rights, or you want to have a right to harvest timber, etc., you deal with the Forestry Commission on that. Then there's a collateral registry, which registers movable and immovable property. And you can register a land or immovable property, that is a land, as security at the collateral registry. The persons that are authorized to sell land in Ghana are the stool, the family, the state, individuals, and corporate entities. The stool must do it in accordance with law, otherwise the grant is void. The stool can sell land by one, if the regent or occupant of the stool signs on behalf of the stool, and this signature must be witnessed by the all the members or elders of the stool. Initially, the law was that the stool, the chief will sign, and then the principal elders of the stool will also sign. The new law, which is the Land Act 2020, is not new, but the Land Act 2020 requires that all the stool elders or stool members sign. That's what it says, which is quite problematic because how I deal with this situation is that I do a resolution and get as many members of the stool to sign, authorizing maybe 2 people or 3 people to sign on behalf of the stool, so that in the event that one or two persons' signatures are challenged, I can fall back on the resolution and say that the authority was conferred on them by these members of the stool. Now, mind you, stool property does not belong to the chief, it belongs to the community. And so the law is trying to ensure that transactions when transactions are done, members of the stool are aware of them and benefit from them. That is why they want as many people to sign as possible. I mean, I believe that that is the rationale for this. Then you also need a consent of the traditional council. Now, the failure of the stool occupants or the elders to sign makes the transaction void. But if you do not obtain the traditional council's consent, it makes the transaction voidable. When we say voidable in law, it simply means that the transaction is valid, but it can be set aside if somebody challenges it. That is what voidable means. So family land is also done similarly with the head of family signing, and then the consent and concurrence of the principal members of the family or family members is shown by them witnessing the document. In this case too, I prefer to resolve this matter with a resolution, a family resolution, which is signed by as many family members as possible to protect or minimize the risk here. Then the state also is capable of selling land because the state also owns land, which mostly are compulsorily acquired. So the most secure land in Ghana is government land because government has good records. They keep good records, and the Lands Commission, which is the entity that is mandated to grant land on behalf of government, is the same entity that records all land transactions and registers them. So state land is more secure than any of the other lands. Then individuals can own land, corporate entities can own land. And when we get to execution, I'll go into some details. Then ownership of land by indigenous citizens and non-citizens. The law has made a distinction between a non-citizen, a citizen, and an indigene, and what they are entitled to, what their entitlements are. With regards to the non-citizen, you cannot have a freehold interest in land. If you are given a freehold interest in land, assuming you are given it, that freehold interest is void. It means that it never happened. So a non-citizen cannot have a freehold interest in land. Now, for those who were owners of freehold interest in land before, before this law has been in existence since 1969. So from 12 August 1969, those who had a freehold interest in land who did not have Ghanaian citizenship, their freehold interest was converted to a leasehold interest for 50 years. So that means that from 12 August 1969, they had only 50 years, and the government took the remainder, which means 2019 was when most of these leases expired. And these people will have to go to government for a renewal. A corporate entity in Ghana is not a citizen if the shareholders, 40% of the 41% of the shareholders are foreigners. If you have 40%, if you have 40% shareholding being foreigners, then you are a non-citizen. More than 40%, then you qualify to be a citizen. So now, as a corporate entity with this number of shareholding, you can now benefit from what citizens can benefit from under our law. The law has also introduced an implied right of renewal, which was never there. However, for citizens, there's no implied right of renewal. It doesn't exist. So if you want to renew your lease after 50 years, then it means that you ought to state it in the lease. At the time of signing, you have to state that you want an option to renew after the term expires. And I also advise that you state the terms and conditions of the renewal, so that when the time comes, you're not now going to negotiate the terms of the renewal. You have them in the lease, in the existing lease. Citizens are entitled to an automatic renewal, except where the lease is in respect of commercial property. So you have to watch this. When the lease is in respect of a commercial property, there's no right of renewal. Or where the lease is property for redevelopment, there's no right of renewal. It's not automatic. It has to be express. So for citizens to advise that you try and put that renewal clause in there. You don't want to risk it. Put it in. The terms and conditions must be in there. For the indigene is the one who I believe is most preferred by the law, because the indigene is entitled to automatic right to renew where the lessee has developed the land for residential purposes, commercial, industrial, and even it has even stated the terms that for the same duration as the original lease when the lease expires. So clearly, and on the same terms. So clearly the indigene is the person who is from that particular area, and the law allows the indigene a right of automatic renewal in most instances. This is a very important aspect, and this is dear to my heart, because a lot of the litigation that I've done, people have been found wanting in this area. And mind you, when a client comes to you as a lawyer in Ghana, the client is coming to you to basically solve a problem which you did not, to fix a problem which you did not create. Because they do their own transaction, they make their own mistakes, and then subsequently they come to you to help them fix it. And so when you go to court, you can identify all the errors in your client's documents, but you cannot say them in court, because if you do, it will not inure to your client's benefit. So this is the challenge. And this is why I feel that these things are important, these presentations, etc. Now, when it comes to preparation of legal documents, the law is that a legal document ought to be prepared by a legal practitioner. So it's only a legal practitioner who can prepare a legal document. Now, even when it comes to a legal practitioner, it has a preference. A lawyer who is in good standing. So a lawyer who has been suspended cannot prepare a legal document. If at the time of preparing the legal document, we can show that that lawyer was not in good standing, had lost his or her license, then that document is not valid. So first of all, a lawyer can prepare a legal document, but that lawyer must be in good standing. Now, when with respect to legal document too, the law says that that document, which can be a sale and purchase agreement, or a deed of assignment, or a lease, or a contract for a lease, ought to be in writing. Now, the due diligence that I did, I'll now try to apply it here. A sale and purchase agreement or a contract for a lease is an agreement that you and I will enter into a lease. However, certain conditions must be met before we do the lease agreement. The condition could be one, that all the payments has to be made before we enter into a lease agreement. So the payment is being made in installments. So you want all payments to be made before we enter into a lease agreement. Another condition could be that after doing my searches, I found out that you owe ground rent, you owe utility bills, you have not obtained the necessary consents, the documents has not been properly signed. You have to go and sign them. The zoning has to be done because maybe the land has been zoned for residential, but you've given it to me for commercial. So you have to go and change the zoning. All these conditions precedent ought to be met before the transfer can be effected or consummated. And so we put that in a contract for a lease, because at this juncture, we cannot transfer if these things have not been done. So that's the purpose of the contract for a lease. Now, the law says this contract has to be in writing. And when the law says it has to be in writing, the writing has been what constitutes writing has been determined by the judges. It's not just black and white writing. The law says the writing must have the names of the parties. It must have the consideration stated in there. It must have a description of the land. It must be duly signed, and it must even have the covenants. The covenants must be there. So if you don't have these things, then it means that you don't meet the requirement of writing. How can you know this if you don't know these cases? So the writing requirements I've mentioned. Then execution. The law says that before you can prove the document against the vendor has to execute it, and it has to be witnessed by the vendor's representative. And before you can prove it against the purchaser must execute, and it has to be witnessed by the purchaser's representative. Now, even the execution, the law has stated the people who can execute. So, for instance, if it is an infant, it has to be executed by an adult who has been given permission by a court, called a guardian. Or if it's an infant or a disabled person, a guardian must execute on behalf of that person. If it is an individual, or if it's a corporate entity, it has to be executed in accordance with the Companies Act. An individual, clearly the individual can execute it. But if you have a power of attorney, the law prescribes that the attorney can execute it in his own name and refer to the power of attorney, or execute it in the name of the person or the principal. So these are the requirements. And if the person cannot read, or let me put it this way, if the person is an illiterate, then the witness must indicate that he has read the document to the person who is supposed to sign, or the transferee, and the transferee understands the contents of the document and has appended his or her signature to it. So execution is also very key. And if you do not meet these requirements, the law says the contract is not enforceable. It means that you cannot get the land. Somebody else will take it. This is also a very key provision in our law, and I'm beginning to use it increasingly, because a lot of people tend to register lands and they don't go through due process. If you go through due process, your registration cannot be challenged. But if you don't go through due process, your registration will always be challenged, even if you have a land title certificate. Now, the concept of overriding interest has always been with us. It's in Section 121 of the Land Act. And it is the one I've used mostly is Section 121F, which says that a person in actual occupation of land has an overriding interest. That person, if you have a registered interest, your registered interest is subject to the person who occupies the land. A person who has been in possession of land for 12 years, I'm talking about adverse possession, has an overriding interest. Now, overriding interests are interests that you will not find at the Lands Commission. No search at Lands Commission will show you that this person has an interest in the land. But you have to go onto the land physically and you will see the person. Now, if you can go onto the land physically and you don't, and then you go and register your title to the land, you think that that person who is on the land has no rights. That person comes at overriding interest. Overriding interest is the highest interest because it comes even before the registrable interest, which is in Section 81. So this provision has come to save a lot of people. My key takeaways are that before you buy land in Ghana, you should conduct a thorough due diligence on the land. You should buy from authorized persons and obtain the requisite consents. And in addition to that, you should take steps to register the land. My caution is that you remain vigilant and approach every transaction as though you were dealing with a dishonest person. Now, as lawyers, we also try to proffer solutions. So based on the problems I have faced, and I have also developed a system which I recommend that you also use. So I've developed an escrow system. In most jurisdictions, developed jurisdictions, land transactions are not handled by the people, the vendor and the purchaser per se. They are handled by professionals. So the exchange of funds, etc., go from one lawyer's account to another lawyer's account after due diligence and everything has been satisfied. You don't have a seller or a purchaser transferring money into the seller's account, and then when the due diligence is conducted and there's an issue, getting the money becomes a problem, and then we have to end up in court. No, it doesn't happen that way in other jurisdictions. So I don't see why we can't do something like that. So we have prescribed an escrow system where the lawyer's role essentially is to manage the entire transaction, including the funds of the purchaser. And until all conditions precedents have been met, and until the lawyer is satisfied that everything is in order, the seller is not going to get a dime. And whenever I'm on a transaction, the person on the other side, I recommend that they get a lawyer. Otherwise, I don't do the transaction, because I know the implication, and there are certain things that you cannot expect somebody who is untrained in the law to understand. So I always recommend that you do a transaction with a lawyer. So I believe this is the end of my presentation. I'll be on standby for any questions.
Thank you very much, Emmanuel. So our second speaker is Nana Otu-Tegson. He is currently the Chief Executive Officer of the Real Estate Agency Council, which is a statutory regulator set up by the Real Estate Agency Act 2020 to regulate the real estate sector in Ghana. As the council's first CEO, his task has been to initially translate the act into a vision for implementation, while putting together the foundational blocks towards the start of formal registrations and regulation. Professionally, he is a fellow Royal Institution of Chartered Surveyors, a member of the Ghana Institution of Chartered Surveyors, and a registered surveyor in Bermuda. He is also a solicitor and barrister of the Supreme Court of Ghana and a member of the Bar of England and Wales, having been called to the bar by the Honorable Society of Lincoln's Inn. We are ready for you, Nana. So whenever you're ready.
Thank you very much, Kensah. Thank you very much. So my presentation is on buying property in Ghana, the due diligence process. I'm going to look at 6 different areas: the land inspection and informal site checks, land valuation, surveys and site plans, environmental checks, specifically on flooding, environmental checks in relation to aviation, and then I'll summarize. So land inspection and informal checks. The question that I pose is, what am I buying of to whoever is buying property? You have to see the land for yourself. And if it's not possible for a lot of people who are not in Ghana, you would have to find somebody who would do that for you. In this process, you must always have in mind what your intended use is. I personally, in a lot of my dealings with land, have felt that if I am offered land or land is offered to anybody who asks me a question, then I'd have to do some sort of background checks before I actually go onto the land. So that would prevent you driving 2-3 hours or wherever to go and see a piece of land which you are not interested in. I normally use Google. There are a lot of other tools there which you can use, and you'd see how I use Google as we go through the presentation. So when you go inspecting land, what are you looking at, or what should you look for? Look for roads. And the experience I've had is our site plans do have roads. A lot of them don't bear any relation to anything on the ground. And the last thing you want to do is to buy a piece of land and realize that you've got to pay other people to get access to that land. In places like England, it is a requirement on your site plan to have normally it would be an easement or some sort of right-of-way leading from a public road. Or if it's a private road, then that should be part of your agreement if you're in an estate. And that should lead right straight to your property. Because if you don't have that, essentially you're landlocked, and it just doesn't make sense that you would acquire property and not have a road leading to it. You would have to consider water. Of course, if it's not in a built-up area, then you're looking at your underground tanks or your poly tanks or your boreholes. You also have to consider what type of soil. So if you're in a vicinity where the soil is firm, then it informs what you're going to build or what your costs are going to be if you're going to build. If you're in a clay area, it would, depending on what you're trying to build, affect the cost of your substructure. You'd also have to consider the topography. The topography would determine how you design, how your uses on the land and your landscaping happens. You have to also look at adjoining uses. So you might be offered a piece of land where your neighbor is rearing cattle or having a chicken farm. When the wind blows and you have built your ultra-modern house there, you're going to smell very, very wonderful smell. So you have to be aware of what is happening around you, if even it is not in full force, just to ask questions and know what is happening. Then the prevalent uses. You might go into an area where the prevalent use is farming. So that informs you as to what the expectation is. Sometimes, and listening to my senior's presentation earlier on, yes, there's supposed to be zoning, but zoning is not everywhere, or sometimes you can't have the information. So you would have to, in your search or going to the site, actually look at what the area is being used for. If it's residential, if it's industrial, if it's commercial, then you should know that that is the expectation, or that may be what you may be bound to. You also have to look at existing boundary markers. Under the Land Act, it's actually a criminal offense to remove any boundary markers, except with the permission of the Lands Commission. So when you do go on a piece of land and those who are offering the land for you are telling you, oh, don't worry, you can take it out, these guys are just imposters who put them there, you have to be careful. And that also tells you what is happening. So in Equiapim, for instance, they have it's a palm plant called Ntome, which they have traditionally used to mark boundaries. You have to make sure that when you see Ntome on a piece of land, and I don't know what the technical term is or the botanical name is, but in Equiapim, everybody knows that Ntome was used to mark boundaries, and you must make sure that if you find one, you ask the right questions. Electricity, you would have to consider depending on what you're trying to build. If you're building a house, you might get a kind of a feed that is good enough for you. If you're building a warehouse or a big industrial complex or a complex of apartments, then you may want to consider what you are getting. You would also have to consider encroachments on the land. Sometimes you might see people farming on them or somebody living on the property. You'd have to ask the right questions. You have to also check your north point. And it's something I guess we all sometimes ignore, but that determines how you're going to design your house or how you're going to design your buildings. If, for instance, you have a house designed where your bedroom is facing the east, in the morning it's going to be very hot. And so you would have to take some of these things into account. And that's why our site plans always have the north point showing where the land actually is laying. A lot of the other search or checks that you have to do has been talked about before, but you have to check the sellers. If they actually have the right to sell, what their capacities are, and that has been touched on. The middlemen. Some people will come to you and offer you land or property. A lot of the times they are doing net selling. So they go out there, ask the seller how much they're selling for, say 100,000 cedis. They come and then they offer it to you at 300,000. So they try strenuously to keep you from going to the sellers. So you must find out what is happening, but ultimately try as much as possible to go to the person who is selling so you can do your own inquiries. You would also have to, if it's possible, make inquiries of your neighbors because they would know a lot. They would most likely have bought from the same landlords or would know of problems in the vicinity. Then you have to check the agreements if they are available. The standard normally is that sellers would not give you the agreements because they say, well, if we give you an agreement and you don't proceed, it's all over the place and we don't know what you're going to do with it. But if you have one who gives you the agreements, then you have to check and see what is in there, what the covenants are. You can have an agreement which says it was bought for farming purposes only, you shouldn't buy it for say residential development or commercial development, even though the Lands Commission somehow appears to say, oh, well, if the town develops up to a certain point, then it doesn't really matter. You can use it for anything. If you ask them whether you can use it for a cemetery, then you'd have a sharp no. So, of course, if I can't use it for a cemetery, then I ought not to be able to use it for anything apart from farming. But it's something that you have to be aware of. Then you have to look at the, if there's a transfer, if there's a lease, again, just touching similar points as point 4, and if there are any court cases for concerning the land. The next point is on valuation. Now, valuation essentially, for me, I think what we pay here in Ghana is more of the worth of the property to us than the price, because the sellers just mentioned their price. And so you would have to decide if it is worth what you're willing to pay for. So how much should you pay for it? You can take the informal route or the formal route. The formal route, if, for instance, you need a mortgage or some sort of finance, or you need some evidence of what the price is, and you would need a valuation surveyor, somebody who is registered under the Ghana Institution of Surveyors to practice valuations, to give you a valuation report. I think that these sometimes have shortfalls, being that we don't have, so for instance, if you go to a valuer who is very well established and has been in the market for a long time, then they have probably enough comparables to give you a good steer as to what the valuation should be. If you go to somebody who is a one-man band who's just done 50 or 60 valuations nationwide, then yes, you would get a value, but as to whether you can hang your hat on that value is another matter. So it is there. Of course, it gives you some evidence that an independent person has assessed the price, but you have to put the weight that you think is reasonable on a valuation report. In terms of informal, that is, if you're not going the formal route and you're trying to have an idea for what you pay, you are looking at the length of interest. There are leases out there that are 50-year duration, 45 years, 75 years, 99 years. You can also have freeholds if you're buying from an individual who owned it prior to 2020. So that should guide you as to how much you're looking to pay, or you could pay, looking at what you've been offered at in terms of price. Then also comparables. So if you have evidence of other properties within the vicinity that have sold, which compared to what you're trying to buy, then it should be a guide. The use, so if you want to use it for a particular purpose and the land is available for a particular purpose, then I guess you're 100% on that. But if it's not, then you would have to see how you either renegotiate for the use that you're looking for, and therefore there would be that knock-on effect on the price. The location, in valuation, we say location, location, location. Of course, if you are looking for a property in, say, Dansoman and you get one, it might be a premium to you to pay more for that property than if you got one in Adenta, which is the other side of town. So the location also comes in. The obligations as well, the agreements that you get given and the obligations that they come with. For instance, your service charge, your repair obligations if it's a building rather than a land, or if it's a land and it's in an estate, your obligations in terms of paying for the common services would also have to influence your thought on the pricing. Then the amenities, what is provided as part of the land that you're being offered, that can also influence your valuation. So ultimately, it is for you to decide. I think that it's difficult for anybody to say if you're offered this price, then that is what is good. If you feel that it is not worth your while, or it does not give you the return that you think is proper, then don't pay for it. Look for something else that falls within your worth bracket. So surveys and site plans. After you've seen the land and you're happy with the price, presumably, you would have to capture the land on a piece of paper. I have grouped these into two different types. One is the basic site plan. Your basic site plan is, as you see on the screen, which it hasn't got as much information as you would find on the next one. This can be a sketch, so long as it's up to scale, because if you do a search in Lands Commission, they require that scale to be able to do that tracing. It can be unsigned. It can just have basic data, as you see, but it has to show the side boundary. Otherwise, it's of no use. Normally, these are used for searches, for discussions, and negotiations. As you may appreciate, if I am going to buy this piece of land, 7.12 acres worth, I would not want to go through the entire site plan process, get it all signed and everything, and then pay all the amounts that I have to pay, only to get to the point where I don't need the land. So this kind of prepares you, and it's a conversational piece of document that gets you to know what you are getting into and doesn't cost as much, but it hasn't got all the requirements that the next one would show. So the next one is a certified and approved site plan. That is, I guess, the highest quality or standard of site plans that you should see. There normally is a barcode. Most regions have barcodes at the back of the site plan. So that's, you see the image on the right-hand side, which is how the barcode looks. Sometimes when you scan them, it takes you to the application. Some of them would give you the Cartesian coordinates of the site plan. You also have the plan data, which basically has the data showing the points of your site, normally coming from your Survey of Ghana geographical point, leading to a specific point on the boundary of the land, and then going all the way out to close, which is what you find in your schedule, in your leases. It also would show your correct details. And I gave the advice that for the surveyors that I use, I always ask them to give me a draft site plan for me to review and make sure the names and everything are correct before they actually submit them. Because the last thing you want is your name spelled wrongly. It goes all the way to the original surveyor, and then it has to be brought back for corrections, and you would have to pay for it, not to mention the time that is wasted. The certified and approved site plan would have to be signed by a licensed surveyor, as you see. So in the box in the bottom right-hand corner, the licensed surveyor has signed this one. Then you have the regional surveyor as well signing it. If you do not have this, you cannot use this site plan for your legal documentation or for registration purposes. And in the Greater Accra region, I find the practice mostly where you will be given a document which has a site plan which you cannot use for registration. What it means then that you would have to go back to the land, get a surveyor to go and do a proper site plan like this. So it is something that you should all be very aware of, knowing what exactly you need in a site plan, especially if it's going to end up in the legal document that covers your agreement. So things to look out for in terms of site plans. Some sellers would insist that you make part payment before they get you onto the land. In some places, they would ask you to give them money for drink and all that. So be aware, it is the practice in some places, because they feel that as soon as they let a surveyor on the land, they pretty much have sold it to you, or you could prepare a site plan and then that's the last they will hear of you. So they're very protective when it comes to that. Who pays for the site plan depends on your negotiations. It could be that the landlord would say, well, I'll put the site plan and everything in the legal documentation in, or sometimes they would say you do it for yourself. It is best to use your own surveyor if you have one, because then at least you trust that they're going to be on your side and safeguard your interest. My senior mentioned about the landlord signing at the back of the site plan. Again, I haven't also seen any legal justification or backing, but it does appear that that is a practice where most people, as soon as when in signing the agreement, will sign at the back of the site plan. The time frame for getting your site plan back, hit and miss, depending on where you are. Some lands commissions have had IT problems recently, and so the backlogs of a couple of months, but ultimately it is not in the hands of the surveyor who submits it. It's entirely up to the lands commission. There can be delays there. Also, the schedule that is attached to a legal document, it has to be a reflection of the site plan. So, of course, it's a professional thing, but if you would want to look at your site plan and the schedule, you should be able to make some sense as to how it is flowing. Sometimes people in a rush to make money, use templates. So I've seen agreements where the schedule is speaking to a different land and the site plan is speaking to a different land. So you have to make sure that your schedule at least reflects the details on your site plan. I've talked previously about asking for the draft and checking the spelling of the name. So do not, at the bottom, I say, do not accept a document with a site plan which is not certified or approved, unless you're using it for basic searches or for conversation purposes. The fourth point, environmental checks, flooding. Are you buying a paddy field? I say. If we're dealing with large-scale development, you're looking at the Environmental Protection Agency Act. You're also looking at environmental assessment regulations. Those would require you to have an environmental impact assessment, environmental management plans, and sometimes would require you to show mitigating measures that would stop the adverse consequences of your development. When it comes to the man or the woman on the trotro, we are looking more at general things that you have to consider. Do not buy land in the dry season. And as you know, we have two clear seasons in Ghana, as best as it is, the dry and the rainy season. A lot of people, some people who know that their lands do flood, would sell you land in the dry season where you wouldn't see what is happening. And also there is a type of grass, unfortunately I couldn't get a picture of it, that grows in waterlogged areas. And it's, as soon as you see it, you would see that this area has some water or has had some water in the past. Also, if there are buildings and you see evidence of rising damp, I know rising damp is also in some built up areas because of water in the soil and the type of soil which does not drain. But if you see something like that, it should tell you that there is some sort of water in the vicinity. There are also some plants that do like water. So for instance, if you see plantain and banana clustered together, it's most likely that there is some sort of water activity going on there. As opposed to seeing, for instance, a cactus plant, which grows in very dry terrain, you would see that there's something you have to take into account. Also use available electronic tools, and I'll go that on my subsequent slides. If you are in the Greater Accra region, there is the GARRET project under the Ministry of Works and Housing that has a lot of data on flood and flood areas or flood-prone areas in Accra that may also be able to help. Basic thing which we've all been told or heard before, if the deal is too good to be true, it probably is. A lot of these lands are sold for very cheap and people rush for them. In the end, they regret that they ever put their money in. You can also do a basic Google search, because these days, when there's been floods in the past, you know, there's been news articles and all that. So just Google and say, floods in Amrahia or floods in Adenta, and see what you get. It may steer you as to an area not to buy in or to buy in. Also, once we have bought our land, the current thing is that you tile the entire compound. Well, what you're doing is that you're creating a basin or a bath. And therefore, if water does enter your compound, then you would have some space to swim. You would also have to provide adequate drains sometimes. And a lot of the times, a lot of our problems with these is just the know-how. Sometimes it's a matter of cost and finance, but if you provide adequate drains, you may be able to get away with these things. Sometimes as well, our neighbors are the cause of these floods, and you have to be able to, you have to get away from our general farmer nyame thing, and you see your neighbor doing something that would affect you, but you're too troubled to confront them, and in the end, it becomes a problem for you. So the use of Google Earth Pro, which is free to download on either Mac or a lot of the environments that we do have. You could have aerial views, you could check your land location. So if you go on a piece of land and you send yourself a WhatsApp location, you can come back, upload it on there and see exactly where. I love doing that because it gives me, I guess, an overhead view of what is happening in the vicinity for me to make a decision before I actually get pushed into somebody who needs my money. The land use history as well is a very important tool. So you can see perhaps over the last 15, 20 years, what has happened on the land. You can also see elevation profiles. And then you can also have an observation of the plot if you're able to plot your plot boundaries on Google Earth. This is Saglemi, which I chanced on. Now, just by looking at it, I see a problem. I do not know what has been done, what environmental impact assessment was done, and how that has or will prevent anything, but it looks to me to be bang in the middle of the lower course of a river. And for those of you who studied geography, the lower course of a river is very slow, but it eats away over time and it can be very dangerous. So this is Saglemi, as we've known famously, and it sits bang, it appears to me, sits bang in the center of a riverbed. If you look at this angle, you can see where the river comes through all the parts of a river. It may not be flooding now, but again, I guess as if we deal with land, like you have London is relying on sewers that were built in the Victorian era because they were developed and designed for 100-year storms or storms beyond 100 years. And that then gives excess capacity for a system to survive. What we tend to do is to be very short-termist. And the question we would have to ask ourselves is, would this development that we have last 100-year storm? If, I mean, Mepe is not very far from this location, is north to that, because north of here is Akuse. And so if we should have any deluge of water coming, what will happen to Saglemi? And I guess it's an advice for all of us as well. If you use tools like Google, you're able to see some of these things before you commit yourself. I have used the same Google to also show what the profile is. So you can see where you see the red arrow here is where you see on this point. So from that point is your highest point and it is sloping down. So if Saglemi is this way, so which is just a little bit below here, if there's water coming down this hill, I don't know what is going to stop it, unless perhaps some levees or some things have been built. And I haven't been there and I don't know what has been done, but this is what Google is showing me. And this is what I think we should encourage for people to do. So you have enough information before you get yourselves into these bottlenecks. I got sent the site plan you see in the little image at the bottom to plot a piece of land which was in Pram Pram. I know now it's called Pram Pram because it has more value than it used to have in the past. And again, the same issues with water and flooding. As soon as I saw it, I told the person, don't bother. It may not be flooding now. As you can see, people are building houses on there. But when I go into the next image, you can see that there's clearly a river. Basic geography, they will tell you that over time, rivers actually make up what we call oxbow lakes. You know, they go and cut parts of, because it's slow and it kind of goes around resistant rocks and all that. But over time, it weathers and it changes. Now, if ever there is an overflow of this river, all this area is going to get deluged. And when I looked at the history of the land use in the area, this was a river. This was a link that came through from there in times past. And I think that has now been dammed for salt. I think it's salt weaning. But obviously, you know, as cheap as this land is, if you're going to buy it, then you must know what you're in for. But these are some of the tools that we can use. This is another one which I wouldn't say scared me, but surprised me when I looked at it. It was a conversation a couple of years ago when the Weja Dam had been made to spill. Now, the area around the Weja Dam is all, I believe, my senior, Mr. Nyidoho, would tell us is part of government land that had been acquired for the river and for water treatment purposes. Now, the same way, using Google Earth to draw a cross-section, you can see that from this point, which is that point, it falls sharply, and everything in here is pretty much in a low-lying basin. So if this is where the dam is, if the river, if there's too much water in the dam and Ghana Water Company decides to spill, everybody in here is going to, you know, and if you look at the heights here, this is 2 meters above sea level, and you're looking at 25 meters. That is, let's even say if your house is higher than 25 meters, that's almost like 25 meters, you're looking about maybe 3-4 stories. You would still, depending on how much water is coming, you're still going to find yourself in flood waters. So these tools are there for us to use. I guess not everybody knows them, but sessions like this would make it possible for people to do these as part of their due diligence, to know exactly where they are buying their land and the risks that they do run. So environmental checks, especially in relation to aviation, is there a catch? Yes, there is. We have the Ghana Civil Aviation Authority. It has its own act, but it's also subject to International Civil Aviation Organization rules. In terms of coverage, when you're around the airport, you're looking at land that is either within the airport's control or that is adjacent to the airport. The main purpose of the control of these lands is that the runway and approaches and takeoffs have to be clear of obstructions. And I guess many of us would have traveled before, the frights that you would feel if you felt that you were going to land or take off in a place that is unsafe. It also has to make sure that the airport is safe and efficient in terms of its operation as a navigable airspace. And it has to also make sure that the signal transmission between the airport and the aircraft are not messed around with. So the restrictions that there are around our airports, that developments within 1 kilometer radius from any aviation installation need approval from the Director General of the Civil Aviation Authority. There are restrictions on height, location, and orientation of structures. Height, of course, because if it's high and it's in a flight path or does affect aircraft, then it's a problem. Location, of course, proximity to the airport. Orientation of structure, sometimes you can build a house and it can be just a very little house. But if it's all glazed and it is in a particular location that is reflecting the sun, then it may very well be an obstacle to aircraft that is either landing or taking off. Also, there are restrictions on the construction materials that are used, like steel, or anything that can generate electromagnetic radiation or fields that would affect either the equipment in the aircraft or the ability of the pilots to actually maneuver the aircraft safely. So it may be necessary for you to apply for obstruction evaluation and air safety permits if you're building within that zone. So I have done another cross-section of the airport area. So this line here, which you see, runs from Bema Camp all the way through to, I guess, Jolu in that vicinity. And this flat area here roughly is where the runway is, or the airport's flat land for landing of aircraft. And you can see, I think Airport City is roughly in this stage. So you can see that, yes, there are tall buildings there, and you would think, oh, why are there tall buildings? But I guess until it has gone past this ridge, then there's no issue. And then you have those other things. So these influence, I guess, the decisions as to where you can build and what heights you can build at. So summary, what are the take-home points? Visit the land or hire a pair of eyes, as I say, to do the needful for you. Undertake the necessary checks. It's very important. Then the price is one thing, but what you pay should be a function of what it is worth to you. Because as I have said, sellers are naming their prices, and rather than get bogged on whether it is right or wrong, you must ask yourself whether it is something that is of worth to you enough to pay for the money or the amount that you're asking for. 3, get the appropriate site plans. If in doubt, pay something small, some local fuel to seek professional help. Then if you do not need a paddy rice field, if you don't want land which you're going to swim in or grow some soggy crops in, then take the necessary precautions. If you find yourself in the mud, just run. Or if you don't want to run, then build appropriately, because water would always come and it would always find its way. Being at the airport may be alluring, yes, high values, but it comes with some responsibilities, so be aware. Finally, don't be in a rush. There is over 84,000 square kilometers of land available in Ghana. You have to get it right. in order to reduce the risk that is associated with the transactions of buying land or property in the country. Thank you.
Thanks so much, Nana. Really enjoyed your presentation. Our final speaker is Mr. Timothy Anyidoho, who's a lawyer and a surveyor and has 20 years of experience with the public service and is currently the acting regional lands officer for the Greater Accra region. Mr. Anyidoho, we are ready whenever you are.
The presentation is just looking at the Institutional Lands Commission because we are the critical and integral part of land administration in Ghana, what we do. I'll go by the guidance of the team to just set some examples of what we look for registration and if there's any advice to give and some legislative highlights that exist. So my first slide speaks to the land question. How we define land in this country is by law. So it's the surface of the earth, water, trees. By my practice, I don't know how many people have come here to register trees detached from land or water detached from land. So just to bring our attention to what the definition of land is, the modes of acquisition are stated by law. I always say that the first two, the first one, which is by gift, and by the third one, which is by purchase, are the common ways. Nobody's conquering anybody now. Discovery, nobody can discover land now because everybody seems to have identified their piece of land. If you are going to purchase land, there's interest you are going for. The law, now Act 1036 tells us the kind of interest that we can register. So there's the alloda, which is the almighty title, what governments, schools, families may have. We have freehold, both common and law. We have usufruct, which is when you are part of a particular group or custom. Or now law says that if you have stayed in a particular place for 50 years and you don't have an arrangement for that staying there. Leasehold is what we often see in this country, which is for a number of years. Tenancies are usually the short-term ones. And licenses are just permissions to use land for a term. Now, there are two basic ways of land ownership in this country. We have public land, which is split into state and vested, and obviously we have the customary land, which involves all other types of ownership, families too. When I talk about the structure of the Lands Commission, you understand why some divisions have been created in the Lands Commission to help the state manage some category of lands. So generally, if you want to acquire land, I've heard from Nano too, I've heard from Mate-Kole, and I've heard they have spoken about many things that you must look out for. I won't belabor the point here. Nano too spoke about the site plan and what you must look out for. The ground validation, he's added a Google to it. Obviously, for Lands Commission, you are looking at conducting a formal search at the Lands Commission, which will indicate to you whether the land has been registered before or not, whether the land has been acquired by state or not, whether there's anything in public records that should advise you on the purchase. I've gone ahead also and stated about what we have introduced by law now, which is large-scale transactions. And these transactions in Section 103 of the Land Act is looking at transactions beyond some land size. The law doesn't talk about the nitty-gritties of what should be done, but I had the privilege of seeing the legislative instruments that would accompany the law. And the whole idea is to raise the bar of how the Lands Commission should process such grants, so that if it is more than 4 hectares for residential, there must be some stakeholder consultations, there should be some discussions at the local assembly, there should be some inspections, there should be some publication in the papers. All these are supposed to allow for acquisitions to be done more transparently, more inclusively, so that if people have some interest in those parcels of lands, they may be able to raise them at the local level to guide Lands Commission, because in the past, people could register even townships and the whole town will not be consulted, and Lands Commission will be looking just at the fact that the grantor had the right to grant. But we are reminded that most of these grants are being held by trustees. If you're a family head, you are holding it on behalf of a family. If you're an occupant of a stool, you are holding it on behalf of a traditional area. And it's important that the people for which you are managing the land understand what you are doing with their land during your term. Obviously, we've spoken about how professionals are important in the process of land acquisition. Nano too spoke about the surveyor and his role. I believe Mate-Kole also spoke about the lawyer. He spoke about escrows. Just in order to insulate you, in other jurisdictions, you cannot just purchase land if you don't have professionals involved. The whole idea is that then you can allow people's professional indemnities to insulate you from the decisions that you take. I set examples. If I'm going to buy a car, it's a second-hand used car, I need some fitter to check for me and to be sure, because I may not be trained in that field. Unfortunately for us in Ghana, most of us try to buy land and act as if we know what we are doing. And without the many things that we've said, I'm sure somebody is listening to us and saying, wow, if these are the many checks I have to do, then maybe buying the land might be tedious. But there are professionals who are trained to be able to help you navigate that process. And I advise that you stick to them. Obviously, I've spoken about Lands Commission and why I, as a public servant and working with Lands Commission, think that it's important for you on this webinar to understand why we are important to you. Like it or hate it, we are a public institution and we have a monopoly. The monopoly is for registration of land in Ghana. And that monopoly is what may have caused some difficulty in the past. But as I present, I'll let you understand that the law seeks to make it better for that institution to be checked in its functions, because you can't register land anywhere except with the Lands Commission. So we are a creature of a constitution, and Act 767, which is the Land Act, which is the Lands Commission Act, has further
Hello, Mr. Nidoho, you dropped off. Mr. Nidoho has unfortunately dropped off. I will check on his rejoining. Please give us a moment. Apologies.
So I'm back. Can you hear me?
Yes, we can hear you now, but we cannot see your screen.
Yes, I just had a somehow I just couldn't find. Okay, so please, can you see my screen now?
Not
Can you
yet.
see my screen now?
Yes, we can. Yes.
Okay, so I guess the last place I ended was Lands Commission and its functions. And as I said, we're a monopoly. We are in charge of registration. Currently, there are 4 divisions of the commission. The other earlier presenters kept hammering on the fact that, for instance, a site plan has to be done by the survey and mapping, has to be approved by the survey and mapping division of the Lands Commission. It's a creature of law, and they are responsible for authenticating or verifying the site plans that are done. The land valuation is responsible for stamp duty and government valuations. The land registration division is responsible for registration. And then the public invested land management division is responsible for the management of public land. again. So part of our functions, again, well, the screen is not shared again. Wow. Okay, sorry. I don't know what's happening, but please, can you hear me now?
Yes, we can hear you.
Yes,
But
okay. So still the screen, I'll have to share the screen again. I don't know what's happening, but the screen worked well when I was listening to everybody, and it gets to me and now. So let me go back. Yes, so I was speaking about the mandate of the commission, which includes advising government, which we have done over the years. But we are under a ministry, the Ministry of Lands and Natural Resources. So we listen to them. All the speakers before me have spoken about registration of title or trying to get your land registered. In Ghana, we have two modes of registration. So in Greater Accra, parts of Kumasi, some experiments in the Winneba area. We have land title in Sabulugu in the northern region. We have title registration. In all the other 14 plus regions, we had deed registration system. Bottom line is that all are registering interest in land. So it is a way of putting your grant in public records so that when people do a search in public records, they will find out that your interest is registered. So for those of you who have bought your interest, you don't register them, don't expect Lands Commission to be able to know that earlier transactions are on them, and therefore others may end up bringing documents relating to that. And if Lands Commission is unaware of that transaction, you run the risk of Lands Commission registering it for you, even though we've been told by lawyer Mate-Kole that as under overriding interest and other things, you may be able to go to court, but always be mindful of the cost of litigation. If you put it in public records, then everybody knows it's there. Then you don't become a bona fide purchaser without notice. You don't have people claiming to be bona fide purchasers without notice, and therefore they could go ahead and register. So why register? It reduces litigation. It makes it easier. We've had court cases where once the evidence of registration has been shown and regularity has been shown, the matter has been done quickly. If you want to transfer, it's done quickly. It enables the proprietor get a loan, and it's useful information for professionals at every stage. I won't speak about the pre-process because I think Mate-Kole has covered it well. Surveyor, lawyer, Texan has also told us the things you have to do pre-registration. So I'll focus on what Lands Commission will be looking at once you approach us. Once you approach us, then we'll be looking for a deed that you have prepared, executed. The law says it has to be done by a solicitor or a lawyer. The barcoded plan is what we've spoken about extensively. The oath of proof is done at the courts. Then you come to Lands Commission again to submit for stamp duty to be done by the Land Valuation Division. And then you submit for registration with the commission. I have tried to show samples of how a land title certificate will look like as a final product. You can see at the bottom the signature of the registrar there. Obviously, it's fancy, looks very nice. That's the ultimate that people are looking for. We've spoken about the barcoded plan a lot. This is a sample of how it will look like. At the bottom, you find out on the left that there are two signatures, one by the lancing surveyor, another by the director of survey or his representative, which is on the right. The codes are at the back. It was introduced in 2015. The whole idea is to allow us for ease of retrieval of these plans once registration comes. And it also helps to verify the authenticity of the plan, since people now have the intention of trying to create their own barcoded plans, which may not be certified. We have also talked about the deed registration system. You will not have the fancy certificate that I showed you above. You would have your deeds that you submitted, but you see at the back of the deeds, there will be certain references, certain stamps that will show the law under which it's been registered. And this would be evidence of the fact that you have registered. So I always advise everybody, once your registration process is complete, it will be important that you go ahead and then have your do a search, for instance, and the search will help you verify if the process was truly done. Because as again, you've been warned about middlemen. People use middlemen. They show them some documents as if it's registered. You don't do a search and you end up coming back years after just to find out that the person just showed you something that was not registered. So always make sure that you do a search after the registration just to confirm what is there. We've spoken about searches. People complained there were delays. It is these delays that advised in the making of Act 1036 that timelines were set in the law, which is 14 days for delivery. When we go to the Attorney General for interpretation of the days, they said any days that is written to public service is 14 working days, not just 14 days, including weekends. So we are advising that when you submit your search within 14 days, which is 14 working days, we should be done with the search results. I must say that is not the case in all cases. We are doing around about 70% for 14 days now, but we are speaking only about Accra. In our regional offices, we are making some 5-6 days for close to 100% of it. So we are not that bad. Technology has been introduced, so there has been efforts to ensure that now some things are done online, not all the services. So for searches, for instance, onlineservices.lc.gov.gh has been the way of submitting searches for Greater Accra and the 6 new regions. The old regions are still old school. You have to go with your site plan to submit, but gradually we are trying to infuse the technology in all the other regions so that we can, at least for the searches as a base, some other services such as stamp duty, we now scan the documents, submission for registration, we scan the documents so that we have electronic backups, even though the full system is not. Put up some sample of searches just to, my internet is unstable. Please, can you hear me?
Yes, we can.
Okay, so I've just put up some sample of some searches, particularly for Greater Accra, one where we introduced the consolidated searches in 2021, October 2021. You find out that on the searches, you have 3 categories of information. That's what makes it even more complex for some people. It's only because the organizations were separate entities until 2008, and records are kept in small bits and pieces. So until 2021, you had to submit to make a search for public invested land, then you do that for survey and mapping, then you do that for land registration division. And it was causing discomfort to people. It was also leading to people to deliberately choose a forum for which search they want to institute which action or to go to the police station. So we consolidated all our searches into one for Greater Accra. In all other regions, it's one search you receive. And it's just like the consolidated search because they have kept records in one place from the beginning. So it's only Greater Accra you will see search like this that has been broken into 3 main categories. You'll find a public invested land division, which will be talking about whether the land is state land or not, and whether there has been any historical, what we call plotting or noting of some transaction in the records. Then the survey and mapping division had to deal with, first of all, requests that were made for survey, to survey plans, just regular requests that were made. That's one category of information. The other one had to do with requests that the land registration division made to the survey and mapping division to prepare plans for them. So it's possible that Mr. A is registering. In the process, they said, oh, a survey and mapping division, prepare a plan towards his registration. So the registration may not be complete, but that information may be indicative of whether there's some activity being processed. It doesn't also mean that by all means, everybody who has information as survey and mapping division will have their interest registered. It's just part of the process. And ultimately, the registrar will make the decision whether to register or not to register that interest. Then finally, you will see that the Land Registration Division will give you information on whether there's a certificate granted or not. So sometimes you get a search where when it gets to LRD, there'll be nothing. They'll just say that no certificate has been granted. That will not mean that somebody is not in the process. It will only mean that nothing, the completion of the process has not been done so that the person will have a land title certificate. So when people do these searches and they are confused about the information, I always say, look to the Land Registration Division as the ultimate, because registration ultimately would reflect at the Land Registration Division. That doesn't mean all the other information is not important. It may be leading or helping you to understand. So for instance, if the land is government land and it was granted to Mr. X, and the information at public invested land indicates that it was granted to Mr. X, you may not find a certificate at the end, but you understand that he has an interest that is registrable. Then I've shown some search from other regions where it's not, you not have it broken down as I indicated earlier on, but still would give you information on whether it is state land or not, whether some family or some stool or some individual has some interest in it, and the last information on whether some assignments have taken place or not. As I indicated earlier on, it's important that technology is infused in our registration process. You heard Nanotu Texan mention that sometimes we've had some technological challenges, so it may have slowed down work. But I always say that we endured with the banks when they started going digital. Now they are far better than they used to be. So we are trying to invest in technology, and hopefully these system down issues will go down, and then we can be more efficient electronically. What are the common challenges? Obviously, the dishonesty of those who are selling land. I always say if you sell the land to one person, it may take 10,000 years, 5 years, 7 years. You are likely not to get any dispute. But if you sell to multiple people, it's just a matter of time. It will show a centralized system of registration. We don't have registration system broken down at the district level. It's all centralized regionally. We are trying to have district offices like we have in Tema, but our base of our information is so centralized that if there's a challenge at the center, usually it affects our nodal offices. The courts are an integral part of land registration. Every day you are getting an injunction or some judgment which is turning a decision that was made at the High Court that is now being overturned at the Supreme Court, that is overturned now, or a Court of Appeal. So every time we have to deal with those challenges. As I indicated, it was only 2008 that we were merged as 4 divisions, which were different separate entities, were merged as one under one institution. So the way our records were kept paperwork, merging them together has been a challenge. Delays in registration process, I'll explain as I go ahead what the law has tried to do to help us do better in terms of the timeline for registration. Of course, some other challenges, the manual environment, the use of non-professionals, indeterminate boundaries, external factors. I always say anytime you hear any chieftaincy challenge, then you know that Lands Commission's hand may be tied soon, because the headships of families tools who own 80% of the land determine for Lands Commission sometimes how we must progress. I always said the example of the Dagbon crisis, and how for the years that the Dagbon crisis were pending, over 20,000 documents became stalled at the Lands Commission because we needed the overlord to sort of endorse the documents until the crisis was resolved. Imagine what becomes of Lands Commission's records in terms of updating its records on transactions that have gone ahead. So sometimes Lands Commission has challenges that are outside its mandate, and that is why the information it gives to you may be limited at a particular stage. Which documents do we advise you to rely on? Land title certificates, registered deeds are number 1, but we also look at judgments that we've received, probate letters of administrations. We also have unregistered deeds, but which trace their root of title from registered documents. So I've had people come here, parents passed or they did something, came to Lands Commission. They may not have the registered document, but they can trace the title to the one that gives them authority. And those are things that you should look at too. We've heard about overriding interest, but I just want to add on the unconscionability of transactions that may void a transaction. So fraud, for instance, mistake, illegality, duress, misrepresentation, undue influence are all conditions by which you may have a registered document, but if somebody is able to litigate with you, he may be able to impeach your title. Generally, I was asked to speak about areas where disputes are generally, is yes, urban centers generally start reeking of litigation. I remember when the oil was found in Accra in the Western region, suddenly the Western region became hot cake. Areas where were quiet, peaceful over a year, suddenly you started seeing activities of land guards and all those things happening there, which didn't used to happen there. So, you know, urbanization attracts people, it attracts a rush for land. Once that happens, I've recently seen the Ashanti region, RECSEC, issue a statement about land guards, and I found it very curious because that didn't used to be the case in that part of the country some time ago. And also historically litigated areas. We all know of conflicts such as the Alavanyo in Konya areas. It's not an urban area. Hills, valleys, beautiful place, but some historical reasons of claims will lead to disputes in those areas. So those are areas to avoid, or areas where you have to cross-check more. Boundaries and overlapping boundaries. Unfortunately, this country has not had a fixed boundary for its regions over the years. And the breaking down of district assemblies. So Lands Commission is working with the Ministry of Local Government to be able to smoothen out what the current boundaries are. And it has affected registration. For instance, some parts, Kaswa used to fall in Greater Accra some time ago. Then it became part of region. Means that people may have central region because we must admit Lands Commission didn't transfer the information across the boundaries to the new regions. So the National Lands Commission has set up a committee to be able to review this. I hope this will be done quickly so that we can have a way to deal with those who have registered their land genuinely in one region and now has fallen in another region. How do we resolve disputes? Luckily, the Act 1036, Section 98, and many other sections in the Act has created room for Lands Commission, once you fall within the registration process, to use ADR as the first mode of registration, even before we go ahead to encourage people to litigate. Obviously, we can't take your right to litigate away from you, and the law didn't say which forum. So now officers are being trained on more on dispute resolution ways, mediation, and all custom, whatever form of dispute resolution, if it is negotiations you want to get to, so that we can reduce the challenges in the courts. A few things to draw your attention to. The Act 1036 has been spoken about intensely, but just to draw you to some few sections. Section 12, which speaks about protection of land, and I highlight on your lawfulness of the owner. People speak about this section, but it is interference with somebody who is the lawful owner, and those who instigate people to use force to guard their land. So we should avoid the temptation of pursuing force, because those of us who finance, those of us who undertake in those things may be liable to long-term prison terms, and that's not what we want. I've drawn our attention to Section 22, which also speaks about limitations on the number of years somebody may give to you, depending on what use you want to use the land for. So if you want to use it for poultry farming, for instance, so if an officer in the Lands Commission sees a document that is for farming, he may ask what the use of what type of farming. If it's for poultry, for instance, the law limits it to 25 years. If it's for the more permanent forms of agriculture, it limits it to 50 years, meaning that you cannot get number of years in excess of this. We may go to other provisions, what we call implied covenants, which are provided in Section 50 of the Land Act. And the limitations that it gives to people, non-Ghanaians, and the guarantees it has for renewal of leases. I've heard people ask all the time, So what happens if my lease expires? Now the law has guaranteed renewal, but for some category of people, we've tried to list them out. If you're a Ghanaian, you're a citizen, you are indigenous, it gives you some room for automatic renewal. If you are non-Ghanaian, then it has to be a covenant in your lease. And yes, you can contract for renewal. You have the liberty to do so. I've also highlighted the introduction of what they call the spousal rights, which is very important. From the day you are married now, when you acquire property, is deemed to be owned by both of you, but it's a presumption. And I say the presumption means that it can be rebutted, and therefore you should not take it as blanket as it is, but you should have an understanding that very soon the commission will be asking people about their marital status, not to intervene in their marriages, but to understand whether their spouse has a share in the property. If it's a gift and you acquired it before marriage, obviously the law exempts same for you. We've spoken about stamp duty has a basis in law. The Act 1036 tries to set a limit for registration because it wants to encourage the Lands Commission to behave better. So if you submit your document after 90 days, the law says you should be informed whether it's registrable or not. It didn't say we should complete the registration. So please, it just says we should be able to inform you whether we can progress with the registration or not. Obviously, state land is important. If your land is going to be acquired by government, government has a right to do so by Article 20 of the Constitution and further provisions in the Land Act. But when it starts the acquisition now, the law tries to cap it in 2 years. The acquisition process should complete. If it's not completed, they should seek for extensions. All this is supposed to help people to have a right so that the Lands Commission doesn't start acquiring property for government and it takes forever. People cannot use their property yet. It is being acquired and you don't know where it's going to. Obviously, you can put in the claim within 6 months. This is important. People should make sure that they put in their claims within 6 months. So going the words that have been said, what are the take-homes from today's presentation? Use professionals, conduct your search. It may not give you all the information, but it will give you useful information. Use an independent surveyor to verify if the site they are showing to you is the site that they intend to give to you. And from all the other presentations, buy right. If you buy right, you get it done right. Thank you very much.
For the very insightful presentation. So now we are coming to our question and answer session. I will read them out, and then if any of the speakers wish to take that question, they can, unless it's marked for a specific speaker. So the first question is, what are the differences in conducting due diligence when a buyer is dealing with an estate property? I assume that means a property within an estate, such as Emmanuel.
Hello. Can you hear me?
Hi, Emmanuel.
Okay. So I'll answer that, but before that, I mistakenly deleted a question. So let me just answer the question for the person. The question was, I stated in my presentation that a corporate body is not a citizen if more than 40% of the shareholding is held by non-citizens, and they wanted to know the authority for that. So it's section 1010. Section 1010 of the Land Act. And then with respect to the question about the differences in conducting due diligence when a buyer is dealing with an estate property, essentially the requirements are the same, except that I would add, in addition to what I've listed, I would add that you have to review the bylaws of the estate, because the bylaws are like the constitution of the estate. So you have to review the bylaws and you have to review their rules. There are rules that may say that you don't keep pets in the apartment. So you have to look at that. And then also management agreements, because in such estates, they have companies that manage the common areas. So you'd want to look at the management agreement to see what the agreement is, the bylaws to confirm what the duties of the management company are, what your obligations are, etc. So these are the things I would add to the due diligence process.
If I could add something. So if for instance, you are buying a building but off plan, what I have tended to see is that a lot of the times the sales and purchase agreement that has been offered is not actually what the paper is written on. So you would have to do some checks on that as well in terms of who you're actually paying your money to. So normally there are three parties. There's the owner of the land, there's the developer, and then there's a joint venture company. You get given an agreement in the name of the joint venture company, but you don't get given anything that links the joint venture company to ownership of the land. And then they would say, oh, by the time we finish building, we would have done the registration. Well, your money is going to a company that has no pedigree and hasn't got ownership of the land which is being sold to you. So things like that you have to look at. And if you're interested, because they are building for you, then you may also have to check the building fabric, the materials and all that, make sure that it is actually what they promised before you actually go ahead and sign on the dotted line. I think Kensah has dropped off.
Okay, then let me see if I can read out. Let me read out the next question then.
Okay.
Sorry about this. Says, in case where you are in possession of a land title but did not follow all processes listed above, how can you now ensure those measures are met now?
Well, I guess you should. I guess you should hope that you haven't done anything wrong. And if you haven't done anything wrong, then everything is fine. But if you haven't followed the processes, and for instance, the person who has sold for you is not the person who actually owns the land, then clearly you don't own the land. So you can't walk back the process unless, of course, you have some sort of an agreement with the person who actually owns the land, and then you walk yourself back in position. But it's difficult to answer without having a specific scenario.
Okay, so this is what I would say. I would say that it's better late than never. You can still get a professional to conduct due diligence on the land. Like I advised earlier on, in order for your land, for you to minimize the risk of you losing title, you have to establish that the antecedent documents were done in accordance with law. So you go back, whoever you've engaged will go back and see whether the ground rent was being paid under the head lease, whether the covenants were being obeyed, and all of that. You ensure that all those things that you fail to do under the head lease, you do them in order for you to be in compliance. Also, if there are any consents that you require, for instance, if before the transfer to you, if the land is state land, you need Lands Commission's consent before the transfer is given to you. So you ensure that you get that consent from Lands Commission. And also the law now is that if you don't have that consent, the land cannot be registered. So you obtain the consent. Even if you register the land, try and obtain the consent to perfect your interest in the land. So, I mean, if ground rents are owed, whatever is owed, ensure that those payments are made. Try as much as possible to comply, basically. The next one is, how long does the due diligence process take? Could that be why people don't want to go through that due diligence process? I think that it depends on, for some people, this thing, it also depends on relationships. Let me just put it that way. If you are able to get the people to follow up and ensure that your searches are done on time, because I am able to get my searches in a week or two, maximum 2 or a week, so because I follow up, I've been doing this for a long time. But I know that ideally the Lands Commission by law is supposed to get back to you, I think statutorily within, I think 14 days or so. So that is the time that you should be looking at. Lands Commission search, all the other searches shouldn't take more than a week. Apart from the land use and spatial planning search, where I agree with my colleague that sometimes some areas are not zoned. And when you do a search in that area, you may never get a search report until the area has been zoned. Do you have anything to add?
Oh,
Well,
just okay. So Nana, please, you first. I'll just to add that as he indicated, if you get it wrong, you've got it wrong. Just try to get it right. There are many ways you can go about that. Possession is key for us in this country. So just find a way to start the process all over. We've had people come here, parents left property for them, brought probates, only to find out that the land is state land and whoever their parents bought it from, they didn't have the right to sell. But the children can now start a process of regularizing it or finding the right documentations for it. So for me, as he said, it's never late to start doing the right thing, because ultimately it will be important to do that.
Yeah. Okay, I was going to talk about the time that it takes for due diligence. I guess it depends. And I try not to be specific with these things, not because I can't be specific, but because every piece of land. So for instance, if it's registered already, then you know you don't have any issues. But if it's virgin land in the middle of nowhere, whatever searches you do, I have had the incidence of, for instance, doing a search for someone, and by the time the person then went on to complete the transaction, a new search showed that the land had been registered, because the Lands Commission does not record applications that are ongoing. They record, or the search, I think they show you if it's been plotted. But so if you lodge it now and then you pay your stamp duty, or sometimes it doesn't show in the search results. So again, I think that rather than think of these processes as time barred, we should consider what we need to do and take our time. It's a way for you to decide. If you think that, oh, I need to rush, a lot of the times things that are rushed always end up wrongly. So take your time, and that's why in my presentation I said we have 84,000 square kilometers of land available. You definitely get your piece. So don't rush it. If, for instance, the Lands Commission search is not coming, just ignore it and then go ahead because the seller is pushing you, all that. Take the time, and most likely you get a proper deal and get the right things done.
Kensah, since you are here, you can take over.
All right. Have we answered the question from Rami A? That is, if you've not followed all processes listed above, how can you now ensure that those measures are met now?
Yeah, I think we've answered that.
Okay. The next question is, what is the process of granting a sublease on a freehold lease? It's a bit off topic, but if anyone is willing to answer.
No, it's just a deed that will be prepared from your interest. You know, a sublease, just like the name is sub, is under something. So, and it's under a lease. He tries to say it's under a freehold or a conveyance. If it's a freehold, you'll be getting a lease, not a sublease. A sublease will always sit under
The lease.
Lease already. So he may be trying to say, you get your lawyer to prepare a deed for you, which will be a sublease document, which will be lesser than the interest that was granted to the person that is above you. And that's all. It's like any other deed that will be prepared. But if it's a conveyance, if it's a freehold, then it will be a lease you get. You won't get a sublease, because there will be no lease to be sub off. You get a lease that will be for a number of years, who may have the same terms and conditions that the sublease that you have in mind covers.
The next question is directed at Mr. Emmanuel. I'm a real estate broker and developer, and I have clients all around the globe. One of their fear is they don't trust agents or brokers in transactions. My question is, how can I get an agent to close a real estate transaction with a lawyer that will make the client trust the agent?
Yeah, I have the perfect answer for that. Is the last slide, the escrow. So in fact, this was developed because I had a lot of real estate brokers approaching me with clients, and we developed a flow where everything goes through the lawyer. And what happens is that, so the funds will enter the lawyer's escrow account. And then what happens is we prepare a document called a settlement statement. So the settlement statement will show how much money has been received, and then how much of that money is going to be used to pay ground rents. Because if the purchase price is 10,000 cedis, and we do our due diligence and we find that 1,000 cedis is owed to the government, we will ensure that that money comes from the purchase price, and it is communicated to the seller. And until all of these things are done, and a settlement statement sent to the client, the payment will not be made. So this is also a way of sanitizing the system and ensuring that, one, the checks are done, two, the land is bought free of encumbrances, and three, the professional, that is, you have a professional or a specialist on the transaction. And in this escrow arrangement too, we have building inspectors, valuers, and surveyors who are part of it. And whatever fees, their fees are paid from the escrow account.
Okay, I guess I can add a little bit, which relates to real estate agency council. So that is an act which was passed around the same time as the Land Act, and that is to regulate the agents and brokers. Once the council is in, full swing and the agents and brokers are registered and have their licenses, I guess that would also bring some sort of credibility, because at this point, anybody can get up and say they're an agent or a broker, and that is part of the mistrust that is in the system. So once that is done, hopefully in the next couple of months, that would also add to the trust in the system.
Thank you. The next question, I am now into land banking, buying of bulk lands from families and stores. How can I enter into this type of transaction when I cannot afford a lawyer in the initial stage? I have viewed some lands I want to purchase, and I want to know the legal way to go about it so I don't get scammed.
I think, sorry, please go ahead.
Go ahead, no.
No, I think we've already canvassed that topic about the legal way to go about it. So you may want to share the video or the slides with him.
Yeah. I think, yes, there is the difficulty generally about lawyers and the pricing and the charging. And I guess where clients or where people interested in the sector would have to look at this from is, you can't do these things on your own if you want to, but what risk do you run? So it might be at a cost, but in the long run, it is in your interest to make sure that you're properly advised, because if you're sick, you would be very careful before you go to a herbalist as opposed to going to a lawyer. So that, I guess, are the options that they have, and they would have to make sure that they do get some sort of advice. And it's not like every lawyer charges the amounts that they're saying. It varies depending on what you're looking for, and so they should definitely use lawyers.
The next one is, I've approached the seller of a land who says he has not registered interest because he doesn't have the funds to do so. I've run a search which is recorded in the name of the guy's vendor, and he tells me that he will let his vendor prepare documents for me because he didn't register his interest. We have agreed to prepare an SPA to guide the transaction. I'm not sure what to say with this person who does not have a record of ownership. If so, what clauses can I put in to protect me? SPA sale and purchase agreement might be.
Yeah, this is a common thing that I come across. So what we do is that we enter into an SPA with the person who is selling, that's the person in possession. And then we'll recite the facts that we've conducted a search in the recitals, and the search shows that the land is registered in somebody else's name. And then we will indicate that as a condition precedent that he is going to procure a lease from that person in favor of the purchaser. That is one thing that will be done. Then he's also going to ensure that all consents, statutory consents, etc., are procured, on the land. And then he's also going to ensure that ground rent is paid in full, and also ensure that any defects in the documents are corrected. So these are all things that you could make conditions precedent in the SPA. But once the transfer comes from the registered proprietor, it means that the purchaser will be able to register his interest in the land. But that transfer, what I will do is that I will recite in the transfer that there was an SPA between this person and that person. I mean, between the person in possession and the person who is purchasing. I'll recite that fact, because the thing about the law is, there must always be a legal connection. If you go to court and you are telling your story and there's this disconnect, you cannot tell who sold the land to this person, your story doesn't sound credible. So at some point in time, that SPA between him and the person in possession ought to be recited. But it's just to show that the reason why it's entering into an agreement to the registered proprietor is because the person in possession has not registered his interest. I mean, I don't know, Timothy, if this is something that you guys accept at the Lands Commission, provided the SPA is stamped.
Yes, definitely so. You just described what it is. The most important thing is tracing the root of title. The biggest challenge with deeds registration in the other regions is that it is by law a registration of one interest to the next. So as he's saying, if he goes back to the grantor, that solves the problem. The challenge is where he prepares the document to the third party and he himself's documents are not prepared for registration under the deeds registration system. And it becomes a challenge because he has to be from one person to the other Under the title system, once they prepare those documents, if it's directly from the person, you don't have a problem. If it is not from that person, it's a third party, you must still procure a copy of the link document. As you said, whether it's an SPA stamped, whether it's a deed of transfer that was done that was unregistered, must be stamped in support of that transaction so that we can find a link between the one we see in our records and the new person you are signing to.
Yeah. The next question is, can it be possible if the family or stool selling the lands for you are offering you a 99-year lease?
Yeah. I think the answer is yes.
Yeah. Sorry, I'm reading. Okay. The question is, if I have land or an agreement which has been executed by the chief of a town, what advice would you give me?
Yeah, so as I had earlier indicated, the chief can only perform this statutory function if the chief has been registered at the National House of Chiefs and his name has been published in the chieftaincy bulletin. If these conditions have not been met, then it means that the chief cannot perform this function of signing, this statutory function of signing documents on behalf of the stool.
Okay.
And then regards to the first
the
question,
next one is sorry.
Also just make it clear that right now, everybody, whether it's to Ghanaian or foreigner, if it's to family clan land, you can only get 50 years. Yes, they cannot, those people cannot give more than 50 years.
I disagree, senior.
Okay. I mean
restriction is just the practice, I think, which came from the Ashanti region, that they'd been granting 50-year leases. The Lands Commission itself was granting 50-year leases for commercial properties. But I have not seen any law that clearly kind of limits terms apart from non-citizens. So you cannot sell freehold, but you can sell freehold if you're an individual and you bought it before 2020.
And respectfully, I agree with Nanotu's submission. The 50 years limitation is just a negotiation. If you are a non-foreigner, or like I said, for instance, the agricultural uses, for instance, where the limitation is by 25 years for poultry, unless there's a statutory limitation on what can be granted, they are at liberty to grant as many years. In fact, the 99 even was just an adoption from the British system. So we don't have a limitation of years per se in terms of grants, apart from the freehold, which has been abolished from families by Section 9 of the Land Act.
I'll throw in this then, Senior Idoho. So I have been told that if a lease was drafted for 150 years, Lands Commission will not register it. Is that true?
That shouldn't be true. Lands Commission will be relying on its mandate under the Constitution on advising traditional areas, because we will think that it will be too long a lease. But if they insist that that's what the parties have agreed to come to, we have no statutory duty and right to prevent people who are really negotiating where there's no statutory bar to enter into a transaction for a number of years. And the House of Chiefs has written firmly to the Lands Commission and to the ministry to alert it on the difficulty in our intervention with their liberty to transact, and that shouldn't be the case. So we'll have to register it. We can try to advise, but we cannot prevent people from entering rightful transactions if that's what they want to do.
Noted.
The next question is inheriting the land from a family member seen the same as the land being gifted?
I have a question again. Hello?
Hello? Hello?
Hello. I do not know if Kensah.
Hello, I know
Okay.
Kensah looks to have gone off. Yes.
Okay.
Yeah,
So,
she's muted her mic, so maybe if we
I think the question is inheriting the land from a family member seen the same as the land being gifted?
Well, I guess inheritance is a gift in one way or the other, but it's the processes to which you come to own the land that differ. So if it's inheritance, then you have to go through the vesting assets and all that. And if it's a gift, then it's just a normal deed that goes through registration. So for me, from my point of view, it's the registration process that differs. But ultimately, in terms of English language, you can consider both as gifts.
The next one is, I have a contribution rather than a question. Okay, let me see. I wish we can have more of such webinars to create more awareness and security for any purchaser. There are just too many land-related issues flooding the courts, and the knowledge shared on here could be a great guide to many when approaching land transactions. So, Kensah, please take over.
You're muted, Kensah.
You're muted.
Thank you. I would like to know what I have to look out for when passing land from a person who acquired the land from the state.
It should be easy. You want to be sure that the person's grant was from the state. Secondly, there are obligations that must be met. For instance, there are clauses such as user clauses. Was you supposed to use it for residential? Then also you find out that there are provisions such as payment of ground rent. Then the parties will be required to apply for a consent. Then the commission will consider that request and grant a consent before it will crystallize a transaction. And then you can proceed for registration.
In your view, how long must a search at the Lands Commission take, and why does it take about 2 months to get results?
So I spoke earlier on that. Now the law says it's 14 days. Maybe just people's lack of education about the law. I have people who have read the law who come after 3 weeks and say, hey, you promised us in the law, it is 14 working days, I'm back. And yes, some get it earlier than that. Some even get it in 4 days, 5 days. Depends on what data we are mining to be able to fill the search. So if someone took 2 months, I can't speak for what we were looking for in order to give the person the right information. So it's by law 14 days, which is 14 working days. However, we also admit that the Lands Commission hasn't met that in all cases. The only advice is better to be careful, to tread cautiously than to say it has delayed. So I'm going to make some payments. And by the time the search results come, you'll find out that you have done the wrong purchase. So yes, the law says 14 days, but it may be longer.
Thank you. What is the process of receiving a valid registration for a property purchased through a court order?
So for Lands Commission, we look at the judgment, we look at copy of the certified plan. And then mostly what we see is that people write to us their judgments, but we don't have evidence of the plan, the basis of which the parties went to litigate. More often than not, these litigations are about interests. And the law, Act 1036 says, now when you submit these things, we must verify with the courts whether there are no appeals pending before we can go ahead and then consider it for registration. So the judgment with the certified judgment plan may be good enough. And sometimes it affects specific instruments. Copies of those instruments also are helpful to the Access Lands Commission registration.
Thank you. How is the Lands Commission working to streamline how lands are acquired and registered in some parts of northern Ghana by the traditional authorities? It appears they are running their own system of registration at a very local level, which offers significant risks.
So there are two ways of solution. The historical antecedent of Northern Ghana is because land was all vested in the state and then divested in 1978, 79, meant that government's control over the land ceased and the various Tindana's family heads took over. There are two things that would help us in the future. One is Section 182 of the Land Act that says now all allodial holders or the bigger holders should make sure that they register their interest before the Lands Commission can register. Secondly, is the law permitting the registration of the creation of what we call customary land secretariats in Section 14 of the Land Act. That means that every traditional area will now have a small secretariat where they can record what they give. They can also have a minimum of a professional. And in the land regulations, the LIs, there's been set some minimum standard of qualifications of those who should occupy those offices, which will help keep better records, be able to also help the customary or traditional areas also have a better system of recording. And we are hoping that as the years prod on, it will become better.
Thank you. Another question for you. How reliable is the search report at Lands Commission? Is there compensation for being misled by a search report?
So the search report will not mislead you because it's a fluid record. And I think Emmanuel Sackitey mentioned that our records are records as at a particular day. Now, if you look at old search reports until 2021, Lands Commission even had a disclaimer underneath it. But in the new law, the law saw that Lands Commission cannot absolve itself completely of any responsibility. So we take responsibility, but we can only report on what we have in our records. So if somebody has bought land and he's not come to us to register, you shouldn't expect us to register on that, to report on that, except the information is in our records and we deliberately ignore to disclose. That the law says that the commission may be liable for that.
I'll add to what Timothy said regarding the searches. So the Land Act, Section 111, says that an entry in the land register shall be conclusive evidence of the title of the holder of the interest specified in the land register. So essentially what it means is that the search, to a large extent, is even more conclusive than the land title certificate. The land title certificate is prima facie evidence that you have title, but to conduct a search, for the search to confirm that you are the holder of that interest, is conclusive evidence of your title. Hello?
Hello.
Are we,
thank you.
is it frozen or?
It's frozen.
Oh, no.
No,
okay,
we heard you.
Okay, good.
We heard you. Yes, please.
No, we heard you, yes, but Kensah is
she's frozen. Okay, then I think what's the next one? I think it's no. Can you see the next question? I lost track.
From the sales and purchase agreement, what other documentation will require a lawyer's review as part of the due diligence process?
So all the documents, every document would require a lawyer's review, from first of all, the site plan, the antecedent documents, the head lease, then if there's a lease that follows the head lease, that will also be reviewed, the sale and purchase agreements, judgments, statutory declarations, whatever documents affects land are legal documents. And a legal document is a document that affects land, including even a correspondence. So all correspondence in relation to the land ought to be reviewed by the lawyer.
Yeah. Okay.
Mr. Texton, has the license process for real estate agents commenced? If yes, what's the procedure?
It hasn't yet. We're hoping that by October, we should have some sort of registration process in place, but it hasn't yet, unfortunately.
Thank you. Is there such a thing as short and long search, Mr. Nidoko?
Definitely no. A search is a search. These are terms that are used just so that people can, in some cases, it's even called unofficial searches and all that. Please make sure that you pay for the search, get a formal and official search. And don't use stuff, including myself, that, oh, can you check this unofficial for me? That may be a person's description of a law. Or a short search.
Thank you. I've seen cases where people in adverse possession of land with title and being in occupation of the land have their lands taken from them as a result of faulty titles. How are landowners with titles protected by these limitations? Why is Lands Commission not in charge of ensuring landowners meet all requirements before registering lands for prospective buyers? It's quite a loaded question.
So I'll speak to the Lands Commission part. Maybe my other colleagues can speak to the other parts of the adverse possession. But basically, Lands Commission and Council Senior Mate-Kole try to draw our attention to the fact that title is evidence of ownership. However, it can be impeached if the process was wrong, if there are overriding interests, if there was something that was in error in the process of registration. So Lands Commission relies only on the information it has and the inquiries it can make during the process and investigates the title. Once it has relied on that information, if something is hidden from the Lands Commission, there is no way, or if a court decides otherwise, that Lands Commission should have made further inquiries, or there existed something that Lands Commission ignored, and the court cancels that certificate, then Lands Commission cannot do anything. What Lands Commission continues to do is to strengthen its processes, such as you go for an inspections, you try to cross-check, so that if we grant the certificate to you, we are sure that you are the rightful owner and you have the right documentation. So the people should help us with giving us the right documentation. If you think you can bypass the system here, people have the right to litigate and they may go and impeach that title. And at that stage, Lands Commission cannot be your defense.
Okay, so in terms of adverse possession, I guess it's 12 years, and so long as somebody can show that they have held the property adverse to the interest of the person who owns it, whatever title they own, whether allodial. I think the Land Act brought in the restriction that you couldn't adversely possess government property. In the UK, you can't, or it has been made more difficult for you to adversely possess a registered title. But in Ghana, there's no such restriction. So it's just a matter of landowners actually being careful, making sure that they occupy their properties, or indeed if there's other people on the land, that they have a relationship, a landlord and tenant relationship with them, and they do not act in any way adverse to the interest of the owners.
Yeah, so that is correct. The Land Act has taken away the right of a person to adversely possess government land only. But in relation to lands owned by other entities like families, schools, individuals, etc., adverse possession does apply. Now, because adverse possession does not apply with relation to government land, however, the possession will not be adverse, it will be possession. Now, the law has a way of treating a person who is in possession of land, how Lands Commission should treat that person before they remove the person from the land. I think it's in section 2365 of the Land Act. And the law is that you cannot just remove an encroacher who is in unlawful occupation of land. You have to follow a certain procedure. And if Lands Commission fail to follow that procedure, then it means that that particular grant that they have given without recourse to the person in possession of the land can be impeached. The procedure is that they have to give the person notice by affixing the notice on a part of the land or by giving it to the person. And if the person fails to vacate within 21 days, then they can now eject the person from the land. So my experience has been that this procedure is usually not followed. Yet the Lands Commission gives grants on lands that are public lands, yet and people are in possession of it. So if this procedure is not followed, the particular grant can be impeached.
Okay, I think Kensah is frozen again. Oh, she's back.
I mean, I don't know if Timothy wants to react to it. He's a bit silent.
No, I agree with what the law has provided. And as I say, the Lands Commission is a public institution, and if it fails to follow procedure, what we are finding out is that the courts are not kind to us because the procedures must be followed. So in most conditions, we try to, but where we don't follow procedure, the court has not been kind to us in showing that we missed the procedure and therefore directs us otherwise.
Hello, I think Kensah.
Hi.
Yes.
Yes, what does it typically cost the buyer to conduct the full scope of due diligence required to purchase a plot of land?
Yeah, I mean, this is the most common question I get, and the answer is it depends, because a lawyer's work is determined by the scope of work. So if, for instance, you bring me a land that has everything intact, they have a land certificate, you have obtained your consent and everything, all I'm going to do is I'm just going to do a review of the documents. And a review of the documents will not have the same fee as an entire scope of work, which requires that I do searches at the Lands Commission, the land use and spatial planning. So it depends. I mean, it's something that you have to discuss with the lawyer, and the lawyer would give you the scope of work, and then you negotiate the fee.
Thank you. Someone is asking if they can get the contacts of all the facilitators. If you have LinkedIn pages, if you could please shout them out.
Well,
Yeah,
my name is my name on LinkedIn.
I can share my contact with the person.
So would you be able to answer the question from your
Yes,
side?
I'll answer the question.
Zero.
Yeah.
The next one is, I don't know whether I am going off topic. I want to know if the registration process you've detailed so far applies to a residential building one wants to purchase, such as buildings being sold by real estate developers. Mr.
So yes, please, the registration process, we don't have different registration processes. It's one process that applies for whatever you want to purchase. And when people emphasize on real estate companies, I always say all the things that we've said, due diligence, cross-checking title, shouldn't be different from buying from a family or a stool than buying from a real estate company. We should not assume that because it is titled a real estate company, everything is kosher and you can just put your money on the table and assume that all the documentation will be done right. Still follow all the processes that have been outlined, due diligence, searches, cross-check before you dip your feet into it.
The next question, doesn't all freehold convert to a leasehold after it is sold? Can you confirm?
No, that is not correct. So there are different documents that you can use to convey. So in law, when you say convey, then we are talking about a deed of assignment, a lease, a sublease. Now, an assignment means that you are giving your entire interest to the person. So there's nothing left. If you give an assignment of a freehold interest, then it means that you have given the person a freehold interest. If you give a lease out of a freehold interest, then it means that you maintain your freehold interest, but you're giving somebody a leasehold interest. So you don't necessarily get a leasehold out of a freehold. It depends on the document that is used.
I don't know if the questioner is talking about the situation where I've heard that in some lands commissions, when you turn up with a freehold document to register, they would ask you to convert it to a leasehold and register. So maybe that's what they're speaking up to.
All right. So if I can clarify, if that is it, then it stems from Section 9 of the Land Act, which abolished restrained families from giving freehold interest. Now, there are many parts of this country where freehold interest was being granted by families. Because for schools that had to be able to be sure that people were not doing documents now and backdating them, because every document before 23rd of December 2020 would be valid. So we've built some internal mechanisms to see when the site plan was done, when the oath was given. If the checks reveal that the document may have been granted after 23rd December, and they are trying to backdate it, Lands Commission refuses because the law has stopped the grants of freehold interest. If it was genuinely granted before 23rd of August, then Lands Commission must, and by law, as directed, continue to register those interests because they were created. The word used in the law was if they were created. So it didn't say if they were registered. So if they were created before the 23rd of December 2020, that we recognize. However, there are some internal checks that if it doesn't satisfy those checks, then people are advised to go back. Then people are advised to go back. And
Thank you for that clarification.
Thank you.
The last but one question. Is it advisable to buy land directly from an owner or a real estate company?
I guess it's 6 of the other and half a dozen of the other, whatever it said. It doesn't really, you're still buying from an individual. So you have to do all from a company. You have to do the same checks and things that we've talked about today. But there's not a big difference from where I sit.
The final question. Please, can one get a freehold on farmland purchase?
Well, if I can answer that, the law just precludes tools from granting, families from granting freeholds. The state too doesn't grant freeholds. So it doesn't matter what you are using it for. It is the fact that they may not have the authority. So whether it's residential, farmland, or whatever, if it was granted after the time the law precludes the authority from granting it, then that will be it. It's not because it is a farmland or not, but it's because the person granting it doesn't have the authority to grant a freehold.
Thank you.
If I may also add that under the Land Act, there's also a restriction now on farming rights. And I think that if you are getting a grant in respect of stool or family land, it cannot exceed a certain number of years. I believe it's 25 years. So that's a restriction. The law has placed a restriction on how many years you can get in respect of farming rights.
Thank you. If anyone has any questions that they have been unable to ask within this session, you are free to send them to my email.
Senior, exactly so,
at
two of the Land Act and the restrictions.
I think there was a problem connection.
Yeah, you are muted, but you are unmuted now, so continue.
Okay, I was wondering if there were any other final remarks from any of you before we conclude.
Let's start by seniority.
Okay, thank you. Let me just put my video on. Yes. So thank you very much for the opportunity. This has been very engaging, and as usual, whenever you are on a panel like this, you also learn a few things. So I'm happy I was called to participate in this, and I'm always ready to engage with my learned colleagues. I also want to leave you with my admonishment from the presentation that when you are doing a land transaction in Ghana, you ought to proceed on the basis that the person or the person you are dealing with is a dishonest person. And it is the evidence or the facts that should disprove that fact. So let them give you evidence to show that they are not being dishonest. So you start from that presumption that they are dishonest, and let the evidence or the documents show that they are not honest before you make any payments. Thank you.
Thank you.
Senior Timo.
I was just following the order of presentation. So if senior texting me, all I'll say is that I have nothing useful to add. Safe to say that thank you for the opportunity to interact again, and we hope that people will learn out of this and buy rights. Thank you.
I would say thank you as well. I step in the protocol already established by my seniors, except to add that sometimes or most often than not, we rush ourselves into these transactions, and that is why we skip the due diligence that we have to have in place. So there's a lot of land available. Even if somebody buys it 6-10 years down the line, it might come back to the market. So take your time, do the right thing so that you don't run the risk of throwing your money and effort away. Thank you very much for the opportunity as well.
Thank you. Thank you all for your time and your effort. Our managing partner, Emmanuel Sackitey, for the opportunity for if anyone has any questions that they have been unable to ask, or be overstated. So let's conduct our due diligence before making any purchases. As Emmanuel said, we have to be wary of these property purchases. We have to approach them with extreme caution. If it was too good to be true, it probably is, according to Nana Otu. And just let us all be careful and do the right thing to make sure that we don't end up losing our investment. Thank you all for joining. Thank you all for your questions. And again, if you couldn't ask your question, please send them to my email. I'm grateful, and have a good evening. Thank you. Bye.